Good evening from Rocky Mountain PBS. I'm Cynthia Hessin. This is Colorado State of Mind. This week at the state capitol, after 9 hours of emotionally charged testimony, a bill to repeal the death penalty was killed by the Colorado House Judiciary Committee, primarily because Governor John Hickenlooper indicated he'd be inclined to veto such a measure. Tonight, we'll talk about it with Democratic Representative Claire Levy of Boulder, sponsor of the repeal bill, along with Democrat Javon Melton of Aurora, and Colorado Attorney General John Suthers, who supports capital punishment and believes especially that it should not be the legislature to decide to end it, but a vote of the people. Also with us, University of Denver law professor Justin Marceau, who concludes in a recent study the death penalty has been applied in an arbitrary manner in Colorado. And last but not least, Greg Dobbs, journalist and writer, whose recent column you may have seen in the Denver Post, voicing his view that the justice of putting killers to death outweighs any argument against it. This year's bill follows a previous attempt in 2009 to repeal capital punishment in Colorado. That year, a group of crime victims pushed to overturn the penalty and to redirect the money the state spends on it to investigations of cold case murders. The bill passed in the House, but failed by one vote in the Senate. Meanwhile, according to the periodic polling conducted by the Gallup organization, public support for capital punishment reached a high of 80% in 1994, 8 in 10 people saying then that it was necessary, and the number has steadily come down each year, but still remains well above 60% in the most recent poll this past December. Let's start with Representative Levy to find out what moved you to bring the bill to the floor or to the legislature this year.
Well, I have long been an opponent of capital punishment, and seeing 5 other states repeal the death penalty in recent years motivated me to take a look at whether the time was right to do that in Colorado. And there was a very large coalition of people working outside the building with the faith community, with victim families, that felt that they had the resources and that the time was right to follow those 5 other states that have repealed it.
And when it died in the committee earlier this week, you had said going into that you felt you had the votes in the committee to bring it onto the floor, but you just decided you didn't want to go up against the governor and put him in a position eventually perhaps of having to veto it?
Well, we went into committee asking the committee to go ahead and pass the bill. We felt strongly that the time was now and that the arguments were on our side. And we actually did put it to a vote of the committee, and 2 of the supporters of repeal voted no, and they did tell me that the reason they voted no was because they were concerned the governor was going to veto it.
Mr. Attorney General, I know that you have probably watched the progress of the bill pretty carefully, and you and another legislator, Rhonda Fields, actually wrote in the Denver Post recently as well. You say that it should only be a vote of the people that would bring the death penalty to the end.
This is a issue, and I've been debating it for 35 years, Cynthia. And by the way, we're not going to change the mind of any of our viewers here tonight. I can guarantee you that.
We'll stipulate that.
That's very divisive. People have very strong feelings about it. The voters of Colorado have weighed in on this a couple of times in the past. And I feel very strongly, and I've always felt strongly, that if it's repealed, it shouldn't come from pressure from what I tend to call the legal intelligentsia, studies about why it's bad or all that sort of thing. It ought to come from the people themselves. And so I've always felt very strongly that, and I'll live, with any decision the people make, that's their view on the death penalty, and I think we ought to respect that. And I also want to emphasize that having debated this for 35 years, I respect the opinions of people who are opposed for moral or legal purposes. But I found out that how you feel about this subject has a lot to do with your experience in life. My experience in life dealing with very serious crimes, the prosecutor, the very first case I had as a young intern at the DA's office in Colorado Springs was the prosecution of Ted Bundy. And after seeing this very intelligent sociopath take the life of more than a dozen young women, I concluded in that case I had no problem with the notion that he deserved to die, that life in prison would not be an adequate response. I haven't lost that feeling about the death penalty. I still think there are certain few crimes being committed in Colorado that any penalty short of the death penalty is an inadequate societal response.
Well, let's hear from a member of the legal intelligentsia, Justin Marceau, who you examined all of the cases that might have been eligible for the death penalty for, 10 years in Colorado?
12 years, that's right.
12 years.
Yeah, and I guess I'll accept the label of legal intelligentsia, but the truth is my approach in doing the study, and I actually did a study on the cost and a study on the constitutionality of the death penalty, along with some distinguished colleagues. I was not to seek a repeal, but rather to just shed light on the death penalty and to add to the debate. I'm not as convinced as Attorney General Suthers that minds don't change. Polling shows that it changes quite a bit, and students in my law school classes have changed their mind over the course of a class and over the course of their 3 years in law school. But the study in particular that I think cast substantial doubt on Colorado's death penalty was a study of 12 years of every murder in Colorado. And what we were looking at was whether Colorado's death penalty applied the standard the Supreme Court has said that we have to apply, which is to narrow the class of death-eligible offenders to the worst of the worst, right? So when the death penalty was last struck down in 1972, the Supreme Court said, it's not that we think the death penalty is morally a terrible idea or that we should even weigh into that moral debate. And I don't want to weigh into that moral debate. Rather, they said, we have to craft a system that makes sure that we get only the worst of the worst. And so Georgia amended its statute, and later Colorado did in ways that were designed to comply with that. And what our study shows is that in 2013, modern Colorado's death penalty statute has put us in the same position that Georgia was in 1972. We've managed to replicate a death penalty system like that from Georgia in 1972. In particular, more than 9 out of 10 people in Colorado who committed murder between 1999 and 2010 were eligible for the death penalty, according to our study.
I hate to cut Greg off before we get
We'll
there.
bring him
First
in
time it's ever happened.
Yeah, this is a very flawed study done by researchers who had a anti-death penalty bias. And he just stated what the problem is with the study. Because Colorado is the only state in the union that to be death penalty eligible, it's not just based on the aggravator. You also have to go through the test of mitigation, weighing, and that determines the eligibility. And they just basically took cases, here's all the cases where an aggravator is present, here's how few were sought. The fact of the matter is the death penalty is working better in Colorado than any state in the union because our prosecutors are going through a very elaborate process of narrowing those cases through this 3-step process, not just the first step process, and only the worst of the worst are facing the death penalty.
So I have to respond, just since you referred to it as a deeply flawed study. It's a deeply flawed study, I guess, from the Attorney General's perspective if he opposes the death penalty. Colorado's death penalty statute is not unique in any sense. Every state in the country does what he says, which is weighing mitigation versus aggravation. There is not a state that has the death penalty that doesn't weigh aggravation versus mitigation. Let me finish. And I guess I would just point out that if Attorney General Suthers is confident that in Colorado it's not broken because only the worst of the worst have been prosecuted by the state prosecutors, I might point out that in Colorado, there are crimes during the study period where parents starve their children to death in the closet, not a death penalty. Executions of people in front of their children, not a death penalty. Serial murders, sexual assaults of women, buried their bodies, not a death penalty case. It's easy to sit here in the abstract and say, in Colorado, the prosecutors have exercised benign, beneficent discretion, and it has saved us all. And Mr. Suthers and I might agree, if we went back to a first position and we were forming a society, I mean, we would agree that we might form a death penalty system that looks a lot different. But as it turns out, we have 40 years of Supreme Court precedent that says it can't just be the discretion.
That is the whole point, Justin. This, by the way, having hosted this show for 5 or 6 years, the longest I ever waited to talk on Colorado State of Mind. Fix all the flaws. Don't erase the penalty. Fix the flaws. And there have been efforts to fix the flaws. The whole system nationwide, where in, I think, 32 states today, it's still a legal penalty for a capital crime. That is the majority of states still see it as an applicable penalty
and
when
Colorado
it's appropriate.
Colorado has more aggravating factors than any of those but
right.
one.
So number one, fix the flaws.
Well,
but my question, Claire,
because
is if all the flaws are fixed, will you then say, okay, sometimes, in some cases, it is an appropriate penalty? If we restrict it to the worst of the worst,
because I think it's not a moral penalty for a lot of reasons. But in addition, since the death penalty has been reinstated following Furman versus Georgia, we've amended that statute 17 times. And it's the epitome of Justice Blackmun's comments that we keep fiddling, tinkering with the machinery of death, and we can't get it right. It was amended to make it easier to get the death penalty back in the 90s because juries were saying, no, we don't want to kill people. So we created the 3-judge panel, which was struck down and found unconstitutional. 17 aggravators exist in law right now. And I went through those aggravators with subsections. I went through those aggravators, and it's hard to imagine a first-degree murder that wouldn't fit in one of those categories. And as Justin pointed out, and I read his study, there are so many examples of crimes that if you just told us the facts, we would say that is the worst of the worst. But yet, death penalty wasn't sought.
Because to the other eligibility factors, and it is eligibility in Colorado, to examine mitigating factors, weigh mitigating factors, and in many of these cases, there are mental health concerns that arise as mitigation.
Sure.
It's a very
deliberative. In the cases with the persons on death row in the state
it is a very serious deliberative process that.
But how do you explain then 4 people for whom the death penalty was sought, who the jury just completely acquitted? You know, if there's such a rigorous review process and everything is weighed in and they're scrutinized so carefully, how do you explain 4 outright acquittals?
A jury of our peers is the best we've got. You know, to adulterate Winston Churchill was the worst form of justice, except for all the others.
Thank goodness.
Right, but Claire's point is, look, if the argument is that Mr. Suthers rejects the Supreme Court precedent that says it has to be a legislative definition, and that's a Supreme Court case. It says at the stage of legislative definition, there have to be aggravators. It doesn't say anything about mitigators, which is a wide open field. It has to be legislative definition that makes it determine objective factors, not mitigation, which is wide open, to determine whether there is a worst or worst. If the prosecutor is going to decide why in only 8 death-seeking cases over the study period were 4 of them kicked by the jury, it suggests that the screening isn't working, right? And more importantly, the fact of the matter is the Supreme Court has told us that we can't just trust the jury. That's what the system was in 1971. I'm sympathetic to your view, but in 1971, it was let the prosecutors decide and let the juries decide. And as I was saying, Mr. Suthers and I might agree that might be the perfect system. We can't design a perfect death penalty. But the problem is it's not working here because we have tried to design a system and it fails.
But I think, you know, we're focusing on this issue of arbitrariness, which I think is a major problem. But there's also the issue which really is what brings me to my position, which is that it is simply wrong to impose the ultimate penalty, taking someone's life by the state, premeditated, when there are other penalties, i.e. life without the possibility of parole, which serves the interest in public safety. It exacts a form of punishment which, you know, the defendant has to live with for the rest of their lives.
Here's what's wrong with that argument. Just this week, the man accused of the Aurora Theater shootings reportedly has appealed for has said he would plead guilty if he's guaranteed life in prison rather than the death penalty. So that suggests...
How does that illustrate what's wrong with that?
It illustrates that he'd rather live than die. It illustrates that death is the ultimate penalty for somebody who chose the penalty himself.
So there are 18 states plus the District of Columbia with no death penalty. Right. Are you suggesting that for somebody who commits a heinous crime in those states that somehow justice is not served, that the people in those states are receiving some lesser form of justice?
I'm suggesting justice is not perfectly served because those people live to eat another day and breathe another day and smile another day and see their loved ones another day.
Live with the consequences of their action. And as Tom Clements, who we all mourned, last week and continue to mourn, said he believes in redemption, and he believes that everybody has some good in them and the power to change. And when you execute somebody, you foreclose that. They never have to.
They have already foreclosed.
They never
They've
have
forsaken
to
their right to
come
redemption.
to grips with.
I just fundamentally disagree with the notion that the majority of people will consider life in prison an adequate response to certain crimes. And let me pose a hypothetical, Claire, which I think will indicate that your opposition goes beyond that mere statement that you made. Let's assume that it's determined that a person in prison serving life, a life sentence, ordered the assassination of Tom Clements. Do you think it would be an adequate punishment for that person to simply continue with no additional consequence?
Well, what corrections officers have said is that that individual would go to solitary confinement and they would live out the rest of their natural life in solitary confinement.
Claire,
and that is in
you're a
fact
lawyer.
where Mr. Montour is to this day, 10 years after he killed Eric Ottoby. He's in solitary confinement and he will never be released.
And all the law students at University of Denver Law School will file suits on his behalf, condition of confinement suits, to make sure that his confinement's not too oppressive. A life in prison in that circumstance for a lifer that either premeditatively kills a correctional officer or orders the execution of a public official outside of prison, I don't think the vast majority of the audience out there is going to conclude that's an adequate societal response.
Well, we're not seeing correctional officers call for the death penalty. We had 2 correctional officers testify on House Bill 1264 that they do not support the death penalty. They would rather see additional resources put into prison safety so that we don't put correctional officers in the position of being vulnerable.
Claire, I used to run the Department of Corrections. Take a poll of correctional officers as to whether or not they think someone who premeditatively kills a correctional officer ought to be subject to the death penalty. It will be overwhelming.
Well, I mean, I do want to point out that the polling that we started out with, there have been recent polls when it's put as a 4-way choice between the death penalty, life without parole, life with parole, and life without parole and some restitution, that by far a majority of the poll takers support something other than the death penalty. So I think the polling, as we all can be sure of, is sort of different. I think if you polled corrections officers, you're probably right. But I think posing distinct questions like that might be a little bit misleading, right? I could pose the question to you, and I think this would be sort of startling to our listeners, which is, do you think that any state where all of the men on death row are black is carrying out a good system? Do you think that a state where all of the men on death row came from the same high school is working properly, or that there might be some geographic arbitrariness?
And you're referring to the situation in Colorado
which happens
right
to
now.
not be hypothetical, which happens to be exactly what's going on in Colorado. I mean, there are lots of questions we can pose that I think would stir emotion and stir trouble. I mean, they're not all helpful, right? I mean, what happened to Mr. Clements is a tragedy, and I would rather not play it out as a hypothetical. I think we could talk specifics about Colorado's death penalty has 3 men on death row. They all went to the same high school. They are all African Americans.
And
they are not the worst of the
committed
worst.
crimes that the majority of people would say, serving a life sentence for killing the witnesses against you, you're otherwise going to be convicted of first-degree murder, and you're going to serve life, but instead you kill the witness against you, and you're going to get no further consequence than if you didn't kill the witnesses?
But there are examples of other cases in which witnesses were killed,
Several.
in which the death penalty was not sought. And that goes to the arbitrariness of this situation.
And it's not just about mitigation. So it's not just about mitigation.
It's a lot about
It's
mitigation.
about geographic location, right? We could pull the files. I've read these files. I have nightmares about these files in the same way that you probably do. I read each of these cases, over 600 murder cases for 12 years, read the files. Some of them are everything that you describe them to be, right?
Yeah.
And we cannot just sit here and pretend that the 3 men who have happened to land on death row in Colorado, they are the worst people to have ever lived in this state. It's just not true.
But
right?
Justin, you're basically making the point that there are more convicted murderers out there who deserve the death penalty
Which is
and
exactly,
simply don't get it.
That's right. Which is exactly the point of Justice Potter Stewart
Fair
and
enough.
Furman in 1972. What he said is a random lightning strike, right, of the death penalty, which means some people who have the worst crimes in the world didn't get it. and some who had sort of lesser crimes ended up getting it. And he said that arbitrariness is problematic.
But the same is true from county to county here in the great state of Colorado.
Which is
somebody
one of the
commits an armed robbery, you get 30 to life, and somebody else gets 10 and they're out.
But
Okay,
that's
so the fact
exactly
that
the
you
problem.
can have a drug offense in Boulder and don't get prosecuted, that you're
That would be
about
my
that,
district
too.
attorney's decision. It's not.
Okay, I mean, but that kind of discretion is
But that is what
But
that
the
is part of
discretion
the
is different
problem.
with
Is that it goes down to, it's not, they may do the same weighing of aggravators and mitigators, but then some district attorneys say, no, I don't choose to use my office resources this way. I have too many other cases to worry about to devote the millions of dollars to death in this one case. Other district attorneys do it. And you can't have a person standing trial for their life where the decision whether they're going to serve the rest of their lives in prison or be executed come down to the decision of a district attorney and their weighing of aggravator, mitigator, use of resources. I want to bring up another issue.
I fundamentally disagree with you.
On justice and the fact that Nathan Dunlap will be the first person executed in Colorado since, 1997. He has been on death row for 20 years. Now, how is justice served? How are we really punishing the worst of the worst when you sit there for 20 years? How does society get closure? How do the victims get closure?
But
and you
been
can't
given
say
those 20 years
shorten
because the
it.
process allows an exhaustive set of appeals.
Exactly.
To make
so
sure
you
that he
can't
deserves
shorten
constitutionally
it.
mandated appeal.
Yes.
Yeah.
That's right.
I mean, you
That's right.
cannot shorten
Whether he
that
wants to or
period of
not.
time without risking the execution of an innocent person or somebody who did not receive due process, effective assistance of counsel. So on the one hand, 20 years is about the best we can do. And on the other hand, we're saying that we absolutely must have this penalty in law in order to do justice, but yet we can't actually use it.
When I did the column a week or two ago in the Denver Post, I got a lot of emails. Most of them were supportive, as a matter of fact, including some from friends who are further left than I am on most other issues. But one of them was from a relative of the one adult killed by Nathan Dunlap, the woman who was murdered at the Chuck E. Cheese. And she said, I wish him a slow, tortuous death. Well, he's not going to have a slow, tortuous death.
won't.
He's going to be put to sleep.
It'll be
I've had 9 major
antiseptic.
surgeries in my life. I was put to sleep the same way. I got to awaken. He doesn't deserve to. But the point is that while some of the victims, who are the survivors of murder victims, some of the victims don't ask for death. Others do. Rhonda Fields, your colleague in the State House, she wants the killer of her son and his fiancée to die.
So then
she
it
says it's
becomes
not about
down-
race, by the way, Justin, even though there are only 3 men on death row and they're all black. She's black. She says it's not about race. It's about accountability. It's about murder.
I did the study.
And if it's good enough for her, then it's good enough for me.
Then it becomes the personal vengeance
No,
of
personal
the victim.
justice.
That we're gonna give Representative Fields or any other victim survivor what they feel is just, instead of, we have a
No,
criminal
they
justice.
alone aren't the determinant.
We have a criminal
societal
justice
retribution.
system that is here to serve society's interests, not to settle scores among individuals. And because I know district attorneys weigh in the wishes of the victim's family, which they should,
Right.
but how do you do that without having it become a personal settling of scores and vengeance, which is, I think, not the role of punishment.
By
in our
balancing it
criminal
with all
justice
the other
system.
considerations they make.
Before we run out of time, tell us about the testimony that you listened to, this 9 hours. It was very dramatic, wasn't it?
It was very dramatic, and the first segment, we kind of divided it, and the first segment was victim survivors of victims of first-degree murder who talked about the fact that they did not want the death penalty, and they were glad that they did not have to endure the anguish of a death penalty case, that they were able to get closure and move on with their lives, knowing that when the jury said guilty, justice was done and the offender would serve that sentence. We had numerous witnesses from the faith community just talk about how justice is served, and that for many of them they feel that that's God's decision and that we should not be exacting vengeance here officially through state policy, and that as a moral matter in a variety of faith traditions that the death penalty was wrong. We had one of Justin's colleagues come and talk about the results of the DU study, and then we had some law enforcement witnesses as well that talked about the fact that they don't find it very helpful. I want to mention, though, two witnesses that it gave me chills to sit next to, one of whom had been on death row in Illinois for 12 years. And he was completely exonerated from the crime of which he was accused. He faced death for 12 years and is a free man today. Had he been executed before those appeals ran out, he wouldn't be here. You can't reverse it. And the other was a prison warden from Oregon, who had carried out a number of executions when I think he was working in Georgia. And he talked about the fact that his employees, who are people who train to be correctional officers, are made to do the bidding of politicians. And they live with the anguish, they live with the trauma of having voluntarily killed somebody.
Would you agree that DNA technology highly increases the certainty that somebody's...
No. There's DNA testimony in about 20% of the cases, and we have examples. Two individuals, they were charged with prison murders, Mr. Bueno and Mr. Perez. It was all circumstantial evidence. One of them was convicted, and after he was convicted, evidence came to light that the prosecutor had suppressed evidence that would have exonerated him.
No one is going to come off the Colorado death row on the basis of a DNA test. These are not whodunit cases for the most part. I just fundamentally
disagree. Bueno and Perez, the prosecutor was ready to execute them both, and they walked away not guilty.
And let me just, I want to reiterate what I said at the beginning, which is that Colorado's death penalty system is a model for a system that is constitutionally flawed. It is a system that is ideal as of 1971, and that we do have great prosecutors, some of the best prosecutors in the country. I will stand by that. But we don't have a system that legislatively defines a class of people who are death eligible. And
last question, short answer. Claire, will you bring this bill again?
Not unless the governor changes his position on it.
All right. Well, that's where we'll end it for this week. That's our program, and you may see it again or any of our recent programs online at video.rmpbs.org. Thank you to Claire Levy and Justin Marceau, also to Greg Dobbs and John Suthers for a lively half hour tonight. We'll be back next week with another edition of Colorado State of Mind, including the scope of the drought facing farmers and now city dwellers across Colorado. Join us for that then, and thank you for tuning in tonight. I'm Cynthia Hessin. Good night.